Hey everybody, welcome to Thursday night. John Skiba here from the Consumer Warrior YouTube channel, and I missed a couple weeks. I apologize. I didn't even put anything up on the thing. Been out of the office for a couple weeks, but I'm back at it here, and grateful to be here on a Thursday evening here in July. And if you're new to the channel, every Thursday night, for the most part, I do a live stream where we talk about all things debt related, whether it be debt collection lawsuits, how to defend them, bankruptcy, wage garnishment, all that kind of stuff. And I welcome your questions. And so the way to do that is if you're on YouTube watching this and you're watching it live, obviously, you can go ahead and put questions into the comment section or the chat area, and then I'll go ahead and put them up on the screen so that we can go over them and address any questions. Now, I always have to start with my caveat that I am licensed in the state of Arizona. I'm an attorney. I do this kind of stuff all day long, but I'm not licensed anywhere else. So particularly if you are not in Arizona, I can't offer any legal advice, but I can't do it really for anybody else either because we're just talking on YouTube. So take it for what it is. That's all it is just a discussion on YouTube. But I recommend if you do need legal advice, you contact an attorney in your particular state. If you're in the state of Arizona, you're seeing my website and my phone number scroll across the bottom of the screen. I do free consultations and would be happy to see how I can help you out. Now, today is July 28th, 2022, and the new numbers came out for the second quarter, and it looks like we're officially in a recession. And it got me thinking back to the recession of 07, 08, which I practiced law during that time as well. You know, there's some similarities, but most things are just different. It seems like, at least here in Arizona, that was all housing driven, where here there's just a lot of other issues going on with inflation, with stimulus funds, with COVID, with car prices. I mean, just things like this. I'm seeing a lot of car defaults on car loans just because the loans are so high. We see dealers ratcheting up the prices on them, and everything's just a giant mess. So hopefully, you know, as you're going into this, if you're dealing with financial difficulties, we can provide some different solutions and some different options to at least think about on how to deal with your debt problems, particularly if you're looking at like a bankruptcy option or if you're getting sued by your creditors. I did go back to the YouTube channel and pulled up a couple questions I wanted to start off with that I thought are pretty relevant to a lot of what I'm seeing here in my law practice. This first question said, "Hi, what happens to auto loans I'm financing in bankruptcy?" This is a good question because I was just talking to somebody on the phone today in a consultation, and they were worried. They thought they were going to be able to eliminate their car loan in a Chapter 7 bankruptcy filing and still keep the vehicle. Unfortunately, that's not true. Basically, the rule is if you're in bankruptcy and you want to keep your car that you have a loan against, you have to continue to make the payment on it. You may even have to enter into what's called a reaffirmation agreement where you reaffirm those terms so that it can be essentially you can just keep making the payments on it. So that's typically what happens, assuming that you don't have too much equity in it. This is where it gets a little bit complicated because each state has an exemption law related to vehicles, but there's a dollar amount attached to it. Like in Arizona, it's $6,000 for a vehicle for each person. And if it's a couple, you each get $6,000 exemption. So you get $12,000 total in two vehicles. But if the amount of equity you have exceeds that $6,000 number and you still owe money on it, you can still lose the vehicle. So this is where it gets to be important if you're thinking of bankruptcy to really, it's helpful to talk to an attorney about it, kind of run the numbers, make sure you're not going to lose anything as you go through that. All right. Do one more that I got. It says, "Can I file Chapter 7 bankruptcy and still attend college because of student loans?" The answer is yes. I filed numerous bankruptcies for people who are going through college or who are planning on attending college. Student loans are often not discharged in the bankruptcy. That's just something to be aware of. And by often not, I mean they're almost never discharged. So the student loans survive the bankruptcy process. And if you're still incurring new loans, the one thing you have to be a little bit careful of, if you're getting new federal loans, it's generally not a problem. But if you're out there trying to get private student loans, sometimes that can, because private student loans are really nothing more than giant credit cards or personal loans that have the protections for the creditor in bankruptcy that make it a little bit more difficult. So, all right, let's jump into this. Man, you guys are already back at it. Al, thank you. Still in Pine Top. I have not been to Pine Top forever. My in-laws live there, and I need to get up there more, get out of some of the craziness of the heat of the valley here. And Dave Lamb, thank you for reaching out. So highly appreciate it. It's good to hear from you guys again. All right, let's see what Mariah Carey has to say for us. What happens if you stop paying on a Chase credit card and you have a Chase bank account? Can they garnish? This is a good question. So there is, first of all, let's say this. They can't garnish, like Chase Bank cannot garnish your bank account unless they sue you and get a judgment against you. So even though they're both Chase, it's kind of like this Chase umbrella, but they have different companies. There's the Chase credit card company and the banking wing of it and all this. And they're going to have to get a judgment against you first before they can actually go into your bank account. Now, one little area where this is not, where what I'm telling you here is not accurate, is with a lot of credit unions. Credit unions, they have different rules that govern them and different laws. And often credit unions will do something called cross collateralization. And what this means is that if you have a credit card and a car loan and a checking account with your credit union, all of that is connected together. And if you don't pay your car payment, they may be able to swipe money out of your checking account. Same with your credit card. If you have a credit card through the credit union, they may be able to sweep the account. If you don't make it, they may be able to sweep your account. So if you have a credit union, it's a lot different, and you got to be a lot more careful. And I don't think most of the credit unions just do it as a matter of course. But I can tell you, like when we filed bankruptcy, and my client has a car loan through a credit union, I'll often have them open up a bank and start banking somewhere else, because it's likely they're going to treat it as a secured debt, secured by that account. So that's where you have to be a little bit careful with that. All right, let's see here. And yeah, that was my, it's getting much harder. And that's kind of what this recession, that's what I'm seeing, is a lot of credit card debt and car loans. So that's the problems that a lot of people are facing now. So you're definitely not alone there. All right, let's see. Al says, according to local court records, Midland filed a complaint against me on June 14th. I've not been served yet. There are no documents of service recorded at the court, and nothing has been left at my door. Since I will be away for a while longer, is there a time limit for service of process? Yes. So, and that gets a little confusing too at times, because so they filed to initiate a lawsuit. The plaintiff has to file the complaint with the court. They'll get it time stamped, and then the court will issue a summons that they take, and then they're supposed to serve you with that. They have approximately 90 days to serve you with the complaint and the summons. If they don't serve you within that 90 days, the courts will typically dismiss the case. Now, they dismiss it without prejudice, and that means that it can be refiled again, and they could turn around the very next day and refile it. What you often will see is that the plaintiff, as they're getting close to that 90 days, and in the Superior Court, it's 120 days, but it's also in Arizona, it's a little bit different, and it may be different it is likely different in other jurisdictions. But if they don't serve you, if they're getting close to that, they'll file a motion to extend the time to be able to serve you timely. But the thing where this can play a big role is if the case gets dismissed, even if it gets dismissed without prejudice, that means that they can refile it. But also, if there is a statute of limitations issue, if they waited until like the last minute, which I see happen frequently, to file the complaint and summons, and now they filed it 3 months ago, now it's dismissed, and now it's just, if they try to refile it, the time period has been not extended, but they're more at risk of running afoul of the statute of limitations because they let 3 additional months go by. So that's one way that it can absolutely benefit you, is if it gets dismissed, you maybe have a stronger statute of limitations argument. One thing, though, you got to be really careful of is sometimes if they don't serve you within that 90 days or it's getting close, they will ask to serve you through what's called alternative service, where they just put it in the mail. They get approval from the court to just put it in the mail. So like someone like that's if you're just out of town, you may want to have someone check your mail, because if they mail it to you, then the clock starts ticking. Excuse me. All right. Let's see what else we have. Dave says, if a judgment against you is reversed, can the creditor still report against your credit report? So judgments themselves are not reported on credit reports. They changed this rule back in 2017. It's not even a rule. It was just the TransUnion, Equifax, Experian, they are just these, they feel like quasi-governmental entities because they run our lives, but they're just private companies. And they decided that they made a decision, all three companies, that they're no longer going to report judgments in the public records section of a credit report. So if you get a judgment against you, it won't show up there. Where it will show up is in the in the actual body of the credit report itself. And there it's not showing up as a judgment, it's just showing as a delinquent or a collection account. So if the judgment against you was reversed, I guess it depends on why it was reversed. If it was reversed because a court said you don't owe this debt, and so it shouldn't have been entered in the first place, then no, it should not still be on your credit report. And if they don't take it off, you can dispute it, provide the credit bureaus through their online process with a copy of your judgment. But if it was reversed on like a procedural issue, like they didn't serve you or something like that, then the underlying debt can still stay. I've been talking too much today. So that should answer your question, but usually the underlying debt will stay, but the judgment won't be there. Karen says, I hope you can give me some advice on this question. If LVNB keeps adding on $5 every month to the collections amount on my credit reports, what can I do? Well, it is, what can they do there? If they keep adding $5 a month on in the collection fee, I guess the question would be whether they're adding it on in interest. If their interest continue to accrue on these things, if they go unpaid, typically they can't add on any kind of fee that's not authorized by the underlying creditor. So if the underlying creditor has had that in their terms and conditions, that they can add $5 a month collection fee, technically LVNB, if they can show that they're the owner of it, they can do that as well. But if they don't, if that's not in the original terms and conditions of the credit card, they can't just add that on. They can't just continue to add that on. So, all right. Let me go over a couple quick other question I had. This one was off the YouTube channel. It says, hi, portfolio recovery just took money out of my account without me knowing. How can I stop them? I don't know why. What can I do? This is a really distressing situation, and I see it a lot, where you get hit with a wage garnishment or like a bank levy, and you weren't even aware that there was a lawsuit or a judgment out there. And the reason why is because once they get their default judgment, they can get a writ of garnishment, they can serve it on the bank, and you don't find out about it until the bank provides you with a copy. But by that point, they've already frozen the funds in your account. Now, in most jurisdictions, you have the right to object to it if you feel that it was done improperly. But you have a very limited time. Like in Arizona, you have 10 days to get that objection filed with the court and get a hearing set. And it's important to know, like in Arizona, they don't allow you to just relitigate the case or even argue that the judgment's invalid because they didn't serve you correctly. You didn't get proper notice. But what you can do is file an objection, and then I usually file right along with it a motion to vacate the default judgment that was entered to show the court that you weren't served properly. There are other reasons to raise objections, like if the account holds nothing but exempt funds like Social Security, you can object to that being garnished. Or what I often see is sometimes I'll see where there's like in community property states like Arizona, they try to garnish a joint account when the judgment's only in the name of one of the spouses. Those are the types of things you can raise objections to make it so that hopefully it'll stop. So, all right, let's see here. See what Kathleen has to say. In Arizona, can you keep an auto and tractor and horse trailer if no equity and continue to make the payments in Chapter 7? This is a good question. So something that's a little bit, I always say bankruptcy is kind of like backwards world where If you have like, let's say you had those same things, a car, a tractor, and a horse trailer, and you owned them free and clear. You did a good job. You paid them off. In bankruptcy, as a bankruptcy attorney, when I see paid off vehicles, I start stressing out because, like I said, you only get one exemption for up to $6,000. If you're a married couple, you can get up to 2 vehicles of $6,000. And if you have a handicap plate, you can get $12,000 as well. So, but the issue is if they're paid and they're worth more than that, and there is no exemption for like a horse trailer or tractor that you'd be able to protect those assets with. But if there's no equity in them, if they're upside down, or if you owe as much as they're worth, then that's fine. So you could have 20 cars if they're all upside down, and you can keep them all in bankruptcy. But if you have 4 and they're paid for, you're probably going to lose at least 2 of them. So as weird as that is, if you have your car, the auto, the tractor, and the horse trailer, and there's still money that's owed on them, there's no equity in them, you can be able to keep them as long as you continue to make the payments in the Chapter 7. So, all right, let's go here. What is the statute of limitations for a debt collection, and when does it begin? A question as old as time. This is the one that can be a little bit difficult because I can tell you what the debt buyers and the debt collectors, what they say as far as the when it begins. They always try to claim that it starts at charge-off. Now, credit cards go into charge-off status after it's been 180 days of no payments. So 6 months, no payments, charge-off happens. They either put it into collections or they sell it to a junk debt buyer. But with the statute of limitations, in most states, it begins when the creditor could first file a lawsuit against you. Well, if you look at the terms and conditions on your credit card, that happens 30 days after you miss a payment. They don't sue you at that point, but they can. And so the fact that they can, I have argued, and I've argued it successfully in court, is that the statute of limitations begins really on day 31 after you miss that payment. So oftentimes, don't take their word for it. Go back, don't look at the charge-off date. Go look and see when was the last time they received a payment. Count out 31 days past that, and that's when that clock starts ticking. And for example, in the state of Arizona, they then have 6 years to file their lawsuit. And if they don't do it in there, they're forever barred from doing it. So hopefully that is helpful. Let's see here. Good question here from Maya Bella Reed. I have a 341 court hearing on Monday. What questions do the trustees normally ask? So the 341 meeting is a meeting in bankruptcy cases, both in Chapter 7 and Chapter 13. 341 just refers to the bankruptcy code section. It's in section 341 that authorizes these meetings. Sometimes it's called the meeting of the creditors. It's usually the meeting of the creditors is usually just you, the trustee, and your attorney. They're all being done telephonically or via video now. In the old days, pre-COVID, we actually had to go down to the courthouse and do it. Something that's weird, I thought the other day, I have not been to the bankruptcy court in almost 3 years. I used to be there 4 to 5 days a week for the preceding 17, 18 years. But now that these meetings are done over the phone or via video, and the U.S. trustee in Washington, D.C. said they're going to be done telephonically or via video indefinitely, forever, which is good. It's a lot more efficient for everybody. So but the meeting of creditors is really this opportunity for the trustee to ask you some questions. I can tell you in the state of Arizona, here's what they typically ask in almost every case. They put you under oath. They ask you if the information you've provided to the court is accurate, to the best of your knowledge. If you listed all your creditors, if you listed all your assets, they're going to ask you if you've lived in the state of Arizona for at least 2 years, if you filed any prior bankruptcies in the last 8 years. And they may even ask a weird question like if you expect to receive an inheritance anytime soon, or if you have a claim where you could sue somebody due to a car accident or something like that. I can tell you with most of these cases, it is the 341 meeting is 5 minutes or less. Sometimes they'll request additional documents and they'll give you some additional time to do it. But usually it's one of these things I tell people that they get really stressed out over. And at the end of the day, they're like, boy, I shouldn't have gotten so stressed out over that. I don't see it as much now that it's telephonic or via video. It's pretty kind of low key. It's really just an opportunity for the trustee to make sure that put you under oath, have you affirm that what you provided is accurate, and then ask any questions. Things that can come up though are like the situation with that question before, with like the horse trailer and the truck and all that. If there are non-exempt assets, they're going to ask a lot of questions about that. Creditors can show up and ask questions. I've been doing this about 20 years, and it's happened about 4 or 5 times. It generally happens in situations, usually like if there's a business owner or the business is shutting down. Sometimes you'll get customers that'll show up, and other times, like in really nasty divorces, you usually get like an ex-spouse might show up or their attorney, that kind of thing. So, all right. Hey, we got Sam Latouille checking in, old football teammate here. Sam, how are you doing? It's good to hear from you. All right. I think that may be it. Let me see if I had one more thing I wanted to go over tonight. Maybe I didn't. Oh, no, I think we checked on them all. So, well, hey, everybody, I do appreciate y'all checking back in, and forgive me here for missing a couple of weeks, but back in the saddle again. Do put other questions in the comments like I do. I pull them out each week and try to put a few of them up here on the screen and go over them. If I can be of help and you're in Arizona, you can check out my information below, call that number, whatever you want to do there. I do free consults. I'm happy to talk to you in more detail about your specific situation. With that, we'll check you in next week.